Welcome everybody. Thank you for coming to our session. I'll also say thank you for coming to Relativity Fest London. Whether this is your first session or you've been here all day, I hope you've had a good time. I've got good takeaways and just enjoying it. So thank you again for coming. Wanted to pull up our agenda, and before we get into the intros and let the panel introduce themselves, I just wanted to give a little bit of background on this session and why we're doing it, how it came about. But we were kind of brainstorming as a team and kind of think what would be a good session to have. How we break it down. We started thinking about certain panelists and speakers that could get involved. And this one came up, and really looking at the teamwork element, right? So from the legal perspective, the technologist perspective, the vendor or your consultant perspective, and it just kind of went from there. And I'm really excited about this and the panel that we've had join. Looking out there, I do recognize a lot of you, but just kind of looking at that, I'm guessing most of you kind of fit into one of those molds, right? Whether you're at a vendor, whether you're at a firm, might be at a corporate or a technologist, right? So again, hopefully everyone does get a few takeaways. I think the conversations and discussions that we'll have will, hopefully be of interest, and the topics that we've picked. And if you do have any questions, we're all for that as well. So, without further ado, I will start at the far end.
Hello everyone. So my name's Jo Livermore. I'm an associate at Stephenson Harwood in their commercial litigation team. I broadly focus on general commercial litigation matters, although have worked on quite a few fraud and asset tracing cases, particularly around sort of East-West Africa. I've also spent quite a bit of time on secondment at an in-house client, so I've sort of seen it from both the client angle and being in the law firm. Generally, my work is sort of multi-jurisdictional, so that throws up all sorts of different challenges along the way, and also been lucky enough to act for a number of different entities, whether that be governance, body corporates or wealthy individuals. And that's really important because the way that you approach the case, and particularly the way you approach matters such as e-disclosure, really depends on the type of client that you're acting for, and the approach that you might take for an individual versus a government, say, will sort of determine how you approach the case, and also how you need and rely on your vendors to approach the case at the same time. Most of the cases are sort of large-scale, document-heavy cases, and so I've got a lot of experience in using different e-discovery platforms and working with a wide variety of vendors. And we regularly instruct tech vendors, as you'd expect us to largely assist in the e-disclosure process.
Hello everyone, my name is Newbury. I'm an e-discovery executive at Herbert Freehills. My primary role at the moment is case management, so we work closely with legal teams and review teams to help manage their e-discovery matters. That's everything from processing documents, preparing documents for review, and documents for disclosure as well. In my previous position, I worked at a vendor, Huron Legal, which is now Concilio. I was a Relativity support team lead, so my role there again was working very closely with kCura's Relativity to build custom workflows for clients to allow them to meet the demands of their review cases, and working with disclosure as well.
Thanks. My name's Al-Karim. I'm from TransPerfect Legal. I am a senior case consultant. I work predominantly with in-house counsel teams and private practice on strategy, on innovation and technology. And a lot of that, given my background, is in the dispute space. Previously, I was a senior associate in a city litigation practice, had a wide-ranging commercial practice, did a bit of arbitration, a bit of litigation, but mainly work that spanned different jurisdictions that was heavy on the data side. So I have good experience from both angles. Great.
And I've not said, it's not the best for last. Paul Gordon, just moderating today's session. I've been with kCura for about 3.5 years. I head up the international solutions team. Closely, if anyone's around for the keynote this morning, part of our customer success team that we've got, and work with our clients. But thank you again to the panel. As you can see, a lot of experience up here, and hopefully we're looking forward to the session that we've got today. So going into the first point that we had up, looking at the whole eDiscovery process and kind of on a number of the calls that we had and kind of bouncing ideas around about a good place to start, a clear kind of question was coming up, and one that we've definitely heard before. But who is really in control of this whole process, right? From the outset of a case, through your vendor, dealing with your technologist as well. So, Al, to my right, a good place to start. Did you want to any opening thoughts on the topic of who's in control?
Sure. I think in this jurisdiction, at least, the law firms are still in control when it comes to eDiscovery decisions. They have the relationship with the tech providers. I think in terms of timing, they often make the decision about when it's appropriate or inappropriate to get in touch with the vendor to scope out what the needs for the case may be. Whether that's right or wrong, I think that's the way it is. The power lies in the hands of the lawyers. Doing some work with the states, it's slightly different there. I think a lot of the end clients, so corporates, banks, they have direct relationships with tech providers. And there are benefits to that. Tech providers get familiar with their data and their workflows. They potentially get engaged earlier. They have transparency of cost. And from the last kind of 18 months, I've seen that it's shifting in that direction slightly here as well. You have a lot more corporates and banks that are investing in litigation readiness, in data mapping, so that when they get to the point where litigation may be afoot, they already have something in place without going through the rigmarole of going through their lawyers. But I still think that's a growing trend, and it's by no means what's happening everywhere. I think when it comes to choosing a vendor, it's not that different to choosing a law firm, to be honest. It's a specialist service. If you're a big corporate like BP and you have a multi-billion pound dispute, you're not going to go to Batman Law to do the legals. So why would you go for a vendor that gives you 10 pence per gig or something like that? And I think that's a mindset change that will happen here pretty quickly. It's similar aspects. Who is the right fit? Most of the big tech providers can do the job. They do the job professionally. They're competent. But for the specific case, who is the right fit? For example, if you have a language-heavy case, then TransPerfect with their language background would be appropriate. For other things, other vendors might be appropriate. The second thing, and maybe even the more important thing, is that relationship, the personal relationship. PMs, when they're engaged properly, can really be a part of the case team. In some of our successful matters, the PMs are on the case distribution list internally, so that if a team needs something at 4 in the morning and the PM is invested, then it just makes everyone's life a bit easier. And I think that's really important. People get on with different people regardless of what they look like on paper. So investing a bit of time at the beginning, getting to know the PMs from the vendor, which ones work for that particular case. I think the overarching thing is probably, when it comes to engaging the tech, getting in as early as possible, collaborating as early as possible. There are answers that lawyers won't have without the tech specialists. There are answers that tech specialists won't know without the lawyers. So it's all about collaborating as early as possible, collaborating often. When you're making decisions about cross-border data or what goes into your disclosure report, what potentially goes into an inter-parties discussion before a CMC, it's always worth having all those things at your fingertips, some of which only the specialists can provide and not the lawyers themselves. So I think that's where I see it.
Okay. Any other thoughts on that?
Yeah, so I'd agree with much of what Al says, which you'll be pleased to hear. But I guess there's a difference between who should control the process and who it is in reality. And I think it goes back to what I was saying earlier about the different types of clients. I think there's no flat line. It really depends on the type of case and the type of client you're working for. Definitely the law firms do control the process to an extent, and I agree with Al with that. We are the ones with the client relationship, and we've generally worked with the client for months, if not years, before we would engage the vendor, before we sort of even get to anywhere near the CMC. And so, of course, we've got much more familiar with the client and their sort of working practices and their IT systems. And so we do control the process in terms of which vendor to engage and the timing of that. But I think it's also important to remember that the law firms are constrained by the client quite a lot. And so, in fact, the client does lead the process and have quite a lot of control over it. First of all, I'd say cost. Even in today's age, it's still probably the dominant factor, I think, in terms of A, choosing the vendor, and B, the timing of it. As much as we and the courts try to encourage the clients to get the vendors on board and get the disclosure started as early as possible, cost is a massive factor in that, and sometimes the case just doesn't warrant the extra cost of getting a vendor on board at such an early outset. I'd also say litigation is a massive burden on the clients, and of course it takes up a huge amount of management time, leadership time. And so, again, whilst we would like to think that disclosure is sort of top of their agenda, ultimately it isn't always. And so strategy in the here and now becomes more important. And I think that's sometimes why I'm sure the vendors get frustrated with the law firms, because we get you guys on much later than you'd like us to. But I think that's just a constraint by the client. And then separately, we have quite a lot of data privacy concerns, depending on which client you're acting for. I've done a case with a Chinese state-owned entity and also a Russian client, and there was no way that anyone was getting their hands on that data other than the law firms. So, but again, sometimes you get much more relaxed clients, and they're just sort of happy to let TransPerfect or kCura or whoever the vendor might be to sort of come and help you out. So I think it's definitely a mix. Law firms do have a lot of the control and the power, but I think the way forward is really to just try and make it as collaborative as possible. I think that will encourage the clients to get you guys on board earlier. And the greater that we can work together and sort of present ourselves as a joint team, I think that will have great effects on the client and how we go forward.
Yeah, I have to agree. I think the relationship between the vendor or the legal firm or the technologists is obviously the key point here. The legal firms or the legal teams are the ones with direct access to the client. But it's the technologists need to have that relationship with the legal team so that they can understand where the clients are going or what the requests are from the legal firm. To understand the background behind them, to really be able to give good advice or direct law firms to a particular direction with their projects. Whether that's building a particular workflow for a particular issue that they have, or advising them on using particular software to help them with that process. So I think it's definitely really key that law firms and vendors or eDiscovery teams have a really strong relationship and work very closely throughout the whole project. In particular, disclosure and preparing for disclosure.
And just picking up something that Al said about choosing the team, I think the right team is so important. And in my experience, the project manager is obviously key. And I've seen some really good project managers and not so great project managers. And definitely, it really, again, depends on the personalities of the client, the personalities of the law firm, and the personalities of the vendor. So it's sort of getting everyone to work together. Also having a case manager who really understands the litigation process and the constraints faced by the lawyer. I think if the three of you can sort of all work together, it definitely shapes and makes the eDisclosure process much more successful and much easier to run. I've had, on a recent case actually, where we've all sort of met together before, and I think sometimes I hardly ever see the project managers, or I don't see them right till the end, but actually seeing the guys up front and either jointly presenting with the client or just the lawyers and the vendor meeting together first, I think sort of you hit the ground running properly in terms of running the eDisclosure process.
And Joe, on that, I was going to, because we have a number of vendors in the room who are probably very interested in a comment like that. You kind of mentioned the project manager being visible, but is there anything else that kind of comes to mind about a takeaway, if you would? But how, if you're trying to engage with a vendor, how would they get their project management team in front of a firm?
Yeah. Well, I guess so. Normally we would see the consultants first, so they're our sort of first line of visibility. And we have a number of them come to the law firms, and obviously we build up relationships, just like Al says, when the clients are choosing a law firm. Obviously, expertise is sort of a given, really. Everyone is producing great expertise, but it's just how the personalities fix with the particular case or particular client. But I think once you build up the relationship with the case manager and discuss the particular case that you're working on, then that's a great time for the case manager to think, right, we need X project manager or we need Y project manager, and then to get the project managers on as early as possible and just keep that visibility. And I often find it just, it makes it much more enjoyable if you know who you're working with and you enjoy doing it with them, but just makes the process run much easier.
I was going to say, I think from the provider's point of view as well, there's a responsibility to try and promote their PMs earlier rather than later, because at the end of the day, they're the ones that will have carriage of that relationship after the initial conferences, for the next 2-3 years. So getting that relationship from their side is almost just as important as for the law firm.
Nick, any last comments? I know you've kind of been on both sides. Obviously, at a firm now,
Yep.
at a vendor before. Any other comments on that kind of the PM I'm guessing having to deal with some in your.
Yeah. I think just go back to the key point. Really, is that it's about building that relationship very early on, and working together to tackle from the start of the case how you proceed in setting up the matter. And from the start, everyone getting on board with it, with the workflow of how the case is going to run. We don't want law firms driving the technical processes, within the technology of how we're going to tackle particular issues. But that said, it's the vendor's responsibility to identify the risks in any given process or any given workflow, any given issue that's come up, and present that to the legal teams along with the solutions to those issues. And it's the legal teams and the clients that have to make decisions on which options we choose, whether we go down route A to fix an issue, or we choose route A for a review workflow, or choose route B. But it's the vendor's responsibility to identify those solutions, those workflows, and present them to legal teams.
Cool. Before moving on, and again, being open, we thought before, because we kind of got it split into different sections, if anyone did have a question before we did move on, please feel free to save any questions till the end. But if you did, or comments, I should say, please feel free to speak up. Okay. Kind of looking back at that second point, kind of again, we kind of just touched base on who's in control, key points on project managers and the teams kind of getting in, making the right impression at the very beginning, sticking with that same kind of theme in a project, right? So when a case comes in, and looking at a data collection perspective, I think we all agreed on some of our calls that getting it right in the beginning was very key. It sounds like sometimes in the past it had not gone right in the beginning, sometimes it had. So Joe, kind of coming to you on this one, if you had any, like at the outset of a case, and any initial thoughts?
Yeah, absolutely. So data collection, in my mind, is probably the most important stage. And I'm not always sure it gets the attention it deserves, because, and I'm guilty of it myself, but we spend so much time, particularly the lawyers, thinking about the review process. And that generally is the sort of most time-consuming and sometimes the most informative part of the e-disclosure process and the litigation procedure generally. We spend so much time thinking about the review process that we don't actually give the collection the attention and the time it needs. But if you can get it right at the outset, then again, that sort of shapes the e-disclosure process going forward and sometimes the litigation. Previous cases have gone before the court, as I'm sure some of you will know, where things have gone wrong. And if you don't get it right at the outset, then the wrongdoers have been penalised by the court, and there are either cost consequences or worse. So I think the courts have shown as well that they endorse that data collection and getting it right is so important. And I think really, a bit like Nick was saying earlier, it's a responsibility on the lawyers to sort of be ahead of the game and instruct the vendors at the right time, and also responsibility on the vendor to sort of create the awareness and educate the law firms where necessary, but also the ultimate client in respect of how collection should and should not take place. I find there's often a sort of struggle with either the clients doing the data collection themselves in-house, and obviously there's cost benefits of doing that, versus having a vendor come in and do the collection for the client on their behalf. And again, it will depend on whether the right case, whether you get the vendor to do it. A recent case I've done actually with TransPerfect, we had a bit of reluctance from the client as to whether in fact their in-house team should be doing collection or not, and it was completely driven by cost. And TransPerfect actually agreed to, or rather offered to sort of do a test case with a test custodian. So they sort of ran the collection and the processing for just one custodian, of which I think there was about 10 or 12. And we compared TransPerfect's work versus against the client's in-house work. And actually the results were remarkably different. So not only were TransPerfect able to get much more data, as you would expect, than the client would be able to, but also once it was processed, the output data that TransPerfect had was so much smaller and so much manageable than the actual horrific size that the client thought he was going to have to review, or rather he thought the lawyers were going to have to review. And again, I think it just goes to demonstrate that the technology and the options available, educating the client that it actually, yes, it may seem like it's an expensive process at the beginning, but thinking sort of about the bigger picture, it's actually about cost saving. And so I think being creative in terms of vendors' cost structures is useful for the law firms and ultimately the clients. So I think that was a useful example of when things went particularly well.
Yeah, I have to agree. I mean, in regards to data collection, of course, it's about proportionality. With smaller cases, low budget cases, maybe small investigations, the clients don't want to spend, thousands and potentially hundreds of thousands of pounds on data collection that early on in the case when they don't really know where the direction the case is going to take. But I think again it comes down to sort of risk management. That stage you don't know where the case is going to go, and the issue I see is that IT teams of clients usually think that they can undertake these tasks themselves. They know the software that the data's held on, and they believe, well, I can get that data for you and give it to you. But the issue is, we don't dispute that they know their software and they know how to use their tools, but it's the process behind them for the tracking and the auditing of what they're collecting and what they're doing, as well as the tracking of things that they're not collecting, and then the tools that we use that extract data in a method maybe that the application isn't able to do. So, for example, we find that SharePoint or file share data is one that, in particular, that we see difficulty in. They're able to provide us the data from their platforms, but they rename the data on the exports, and they do all these things with the data that essentially, when it comes to us, it's not the format that we want them to produce. And these documents may eventually go over to an opposing party, and they're trying to compare these documents with documents that they've collected, and maybe they've collected them differently, and they're not going to match them up, and it just poses a risk, obviously, on the legal teams then, having to clarify sort of how the data was collected, and a risk for the client. If the client's undertaking this collection themselves, they're putting that risk on themselves to get that collection right. So I think, regardless of whether the case is small or large, if clients don't have the workflows and the experience with data collection themselves, I would always advise to still seek advice from a vendor or a service provider, whether that's sending someone out to do collections or just getting someone on the phone to speak with the client and talk them through, speak with the IT teams, talk them through, guide them through collecting the data, maybe remote sessions and things. There's other things that we can do that are low cost, but they can ensure that we still get data collection correct.
I think that's right. With a lot of this stuff, it's the education of the end client, which is the important thing. Like they're trying to save costs. Law firms are trying to save costs, but they have to understand where it's appropriate to save costs and where it's not. Actually getting the data collection right from the beginning is so important for defensibility at the end of the process. And it can result in anything from sanctions to wasted cost orders. The way that I think it sometimes works to explain it to them is that your internal IT function have a job description. Their job is to maintain the IT systems to make sure the business is functioning. Their job is not to forensically collect evidence, whereas most forensic technicians, that's what they do every single day. They have protocols they follow. They have defensibility protocols. They have to ensure that data is preserved correctly, and that is their job. And when you're looking at building the foundation of a case, you need to get that initial aspect of it right. Beyond the cost, even for your own benefit, if you are looking to collect documents to put your best case forward, you need to collect all of the documents. I think technology's come far enough that you can collect a wider set of documents, and for not too much more, using early data analytics, you can process those documents quickly and cull them down to a much more focused set, whereas maybe 2 or 3 years ago you couldn't, and actually collecting hundreds of thousands of documents meant that you'd have to then do something more substantive with them. And when you look at the internal file structures of a lot of organisations, they don't have basic functionality like, for example, indexing, which most processing tools do. And if you haven't got all the documents indexed, you can guarantee that if something's been copied and pasted from one drive to another, the metadata will change, and there's a lot of case law around preserving that metadata, because at some point that might become an issue in contention at court. And if you have messed around with that metadata at the beginning, then you're going to be liable for that. There's a West African gas pipeline case where I think they didn't do the initial data collection properly, and it contributed to an 80% wasted cost order at the end. There's another case, Muller, I think, where the court actually imposed a forensic expert on one of the parties that refused to do the same, because they saw the need to collect that data correctly from the outset. So I think, yeah, it's as much of an education as anything, but if it's not done properly, you can run into real defensibility problems further down the line, which for any client, if they're being honest to themselves, is way more important than the actual cost of a few £1,000s of a forensic expert's time.
I mean, all those kind of listing out all those reasons about why defensibility, doing it correctly, not spoliation of any kind of metadata. I mean, it all sounds as pretty good information to provide to provide to the end client, rather than them to say, well, it's going to be cheaper for us to do it. Is there? I'm just trying to think. Is there any kind of? Are there any hurdles that just maybe that information's not getting through to the end client? Is there any other thoughts on how that would actually get done? Engaging a vendor that might do a collection earlier in advance?
Well, I mean, what we're seeing is becoming way more common is actually the lawyers are much more knowledgeable. They have a much better understanding of this, because the law on preservation is there. And so to ensure they're doing it correctly, sometimes they go to the end client and they're very keen on having one of the forensic techs on a call or flown out to a meeting, so they can actually firstly explain why it's important, but secondly, as Joe said, maybe demonstrate that very quickly. So that's one way we're seeing it. I don't know if you guys have seen any other ways that are useful.
Clients definitely like to see results, and obviously if you can actually demonstrate and show them something, then you're sort of halfway there, I think, to getting them on board with your proposals. A couple of useful things that we do at Stephenson Harwood, and I'm sure others do too, in terms of starting the process early, but we have a simple sort of do's and don'ts list for collection, sort of highlighting the importance of it and the consequences of not doing that. And I think if you can put that forward together, either with your vendor or without, that's quite a useful starting point. We also sort of use custodian questionnaires at the beginning to really try and understand, the client's IT systems, but also their working practices. How do they actually sort of use this data over time? And another useful thing I've seen before is getting the vendor on board for the eDQs. So I've had a number of cases where, in fact, the law firms have done the eDQs on their own, and the vendors don't come into much later. But actually, if we can get the vendors on board much earlier, or the in-house tech guys, and to help with the eDQs, they definitely pick up on things that the lawyers wouldn't pick up on, because it's their expertise, not ours. And also analysing the other side's eDQs, it can definitely give you a competitive advantage if you've just got someone else looking at it from a different angle, to sort of forensically analyse what are the other side doing, and whether you can criticise that, and if they should be doing something more. So just a couple of things to start it early.
I imagine that would come across looking very well from your perspective, is from dealing with a corporate, kind of posing that you know what you're doing. Listen, we can do it this way rather than just the cheapest. So.
Yeah.
All right. Any other questions or comments from the crowd? Anyone? Jonathan.
More of a suggestion / question. who would work on a lot of legal matters, and they'd have the experience, but they're not always the people who were involved at the beginning. So as a suggestion to law firms is maybe at the beginning of a case that you have a nominated litigation person who is put to the client at the beginning. I've had cases where a particular lawyer I was working with hadn't done a case in a year or so, and I had turned up to do a collection for a client who had done a search in Windows XP to find the documents, having been told by the lawyer that, yeah, you can go find the documents yourself. Yeah. So there was, I don't know, a few hundred documents found in Windows, and I went up and closed the window, and he said, that took 4 days to run. So you wasted 4 days of your time. You've wasted 4 days of my time. It would have cost you a few thousand euro for us to go and do that for you. But I think it's very important that, because the lawyers do have the sort of the gateway, they are the key holders, that it's important for them to really hammer home at the very beginning just how important it is, as you said, the do's and don'ts. It's very important that those do's and don'ts are made clear at the very, very beginning of a case.
Yeah, absolutely. Well, I guess it goes back to the point we were mentioning earlier about sort of collaboration, and I think at the moment perhaps we're not working together as well as we could be, and so in terms of sort of presenting a joint approach, and whether you have a nominated person within the law firm and a nominated person within the vendor, but I guess that joint approach. And I think the lawyers to some extent do need some education themselves around as to the tools available. We sort of get our legal brains on as to what we need to do under the court rules, but we're definitely getting better at it, I think. But sort of knowing the techie tools that are available in respect of data collection, whereas the lawyers either want to print out all their documents, which I know frustrates the hell out of you all the time, or they want to spend 4 days searching for documents, which you guys could do in 30 seconds. So
and forwarding emails to me. That was the other one. I got 4,000 emails into my inbox one day from a guy who was just forwarding me all the emails.
I'd never do that.
Just delete them all and take it again.
No, I have to agree. From a vendor's point of view, I've seen the same issue. Vendors being brought on to matters, after the collection's taken place, and they just get sent a hard drive, have no idea how that data was collected, where it came from, and there's their responsibility then to process that data and present it on a platform for review and disclose it. And the kind of risk then is felt to be put on them. And that's why, in comparison, working at a law firm and having much more access to the legal teams, I've definitely seen the benefit of getting on calls with the clients and the legal teams much earlier on in the cases, before collection has started, maybe just to get on calls and talking about collection with clients and about how to tackle the issue of data collection and the benefits of, I've seen the benefits of doing that. So yeah, I definitely advise, for legal teams to, if they are working with vendors or in-house, to engage their discovery teams or their vendors much earlier on in the process, to start talking about collection.
Excellent. Thank you for the question, or comment. All right. Okay, and always a fun topic. And in thinking about assisted review, we could wrap in analytics as well. But and we weren't going to get out of a session without bringing this up, so we had to save it for the last one. But kind of posing this question as kind of assisted review and where we are now. Thinking back to Relativity, or not Relativity, but our last Relativity event last year. Right around that time, there was a big decision that came out. The UK, we finally had a ruling that was out there that says kind of the approval, gave the thumbs up. It also gave us, it was great timing for us because it gave us a session that we could plug in and talk about assisted review, being the Pyro case. It also gave those guys a lot to do for the rest of the year and keeping them busy for a number of different conferences. But it was all really good. It was great exposure. We're talking about analytics. We're talking about advancement in reviewing documents. So kind of a year-ish or so on, wanted to see, Nick, if you had any thoughts on kind of where are we now?
Absolutely. So, assisted review analytics has been around from a technologist point of view for quite a long time. I've been talking about assisted review since I started in this industry and using analytics from the beginning. But what I find is that it's the way it's used that sort of fails it. I think, in particular with assisted review, I don't think legal teams necessarily have issues with the technology behind assisted review and and how that works, and the confidence in assisted review itself. I think what the issue is workflow. I think it's really important for the vendors or the tech teams to be able to present legal teams a workflow for using assisted review. And that's where I think a lot of the shortcomings are in the uptake in assisted review in the UK. What are your thoughts on that?
Yeah, so I would agree. Obviously, analytics, the sort of basic analytics, have been around for a long time, and I think they're part of standard practice. We generally would always use enhanced deduplication or threading, and I'm not going to pretend I know all the techie terms for it, so I'm going to leave it there. But in terms of sort of standard analytics, I think that's definitely part of the lawyer's way of working and how we would approach e-disclosure. Assisted review, it's obviously been around with you guys for a long period of time, but it is still quite a new concept to the lawyers. And yes, the Pyro case last year was brilliant in terms of sort of endorsing it and setting the path for the way forward. But I think there probably is still some skepticism within the industry generally about sort of computers doing things that the lawyers can't. And I think that is going to take some time. I've certainly seen, and in fact Al and I were talking about this previously, I've certainly seen there's more inquiries and we're sort of more interested in using assisted review, but I haven't actually seen it in practice yet. And I think A, that's because you need the right case, and some of the cases we do every day simply aren't right for assisted review. But B, there is still, I think, a few stepping blocks to go in terms of the awareness and the education point, both for the awareness to the law firms as to what this technology actually does, and two, for us then to pass that on to the client. I think also I found some sort of limitations around spreadsheets and numbers and comparing the spreadsheets, and also hard copy documents. Like I've done quite a lot of work in the aviation space, and the clients, the airline clients, they just have huge numbers of hard copy documents, and actually that wouldn't, I don't think, unless you're going to tell me otherwise, is necessarily the right sort of client and the right sort of case for assisted review, because there's just too much manual work to do in the hard copy documents. So I think it's coming around, but it's still taking a bit of time.
Yeah, I mean, I think it comes back to the responsibility of the technologist or the vendor to work with you and advise on those situations, those issues. And again, put workflows in place to work around particularly difficult documents. I would say for anyone not confident in using assisted review, to give it a go on a matter maybe we haven't used assisted review at the end. There's nothing. I mean, you speak with your vendors and your technologists, but it's absolutely possible to run assisted review after review is completed to test the results of assisted review. You may find that there's documents you missed, or you may find documents but the technology is there, and it's most vendors have it available. So I definitely encourage people to use it.
Is assisted review only used generally for e-disclosure cases, or have you found, in terms of doing preliminary reviews, which I'm finding more and more, we're sort of using shredded down, slimmed down platforms when we're sort of just setting the case out at the outset?
Yeah.
Presumably, from cost, would you just use would you use the assisted review much later down the line?
It's a very flexible tool in the same way that email threading and finding similar documents is another tool on the belt. Assisted review can be used in the same way. So we have matters where legal teams are just poking around documents, very on the case, maybe for the CMC, and there's no reason why you can't take the results of their work in building a defence and use assisted review to then assist that process. So it doesn't necessarily have to be used just for review purposes. It's definitely a tool that can be used in other means to find documents if there's been an initial review that's taken place for some other reason.
Can I ask?
Yes, you can.
Stupid question, but I've been struggling with the idea that for some reason assisted review is the one thing that seems to cause the most attention. But every single thing.
Every single thing that we have in our tool belt is technology at some level. So at what point I don't know whether it's the legal system or the judiciary, has decided that this particular thing is the one that's going to cause the most like OCR, it's incredibly difficult, complex, computationally expensive thing to do, but it was sort of just accepted, and it's gotten better over the years. But when it was in its infancy, it was horrendous. It was, the results were almost useless. And now we got to the stage where we're getting to the stage where it's getting better and better, enough that it's somewhat reliable. So at what point did we decide that technology is not reliable anymore?
I think a lot of the other analytics, they're almost software in a way, so they can be applied to data sets. But the line is kind of drawn at assisted review, because it's literally replacing the work of what traditionally lawyers have been doing for hundreds of years, like sitting down and page-turning documents. And there's this mindset that if you're not line by lining a document, you're going to miss something. So I think it will take a bit longer for them to accept that is a form of technology that they're comfortable with. Whereas if you look at some of the other analytics, like clustering or OCRing, they're things that aren't replacing the task of a lawyer. So I think that's maybe this. I think you're right. I don't think there is much of a distinction. I think that whether it's predictive coding or OCR, all of it falls under analytics, and it should be employed in the same way. And what Piro has done, it may not have increased the use of predictive coding, but it's definitely, I think kCura had something like 400% more inquiries last year on predictive coding. Hardly any of them turned into actual workflows. What it has done, and we've seen this year, is that clients are much more willing to engage in all of the other analytics because they feel a bit more comfortable with them. And I think it's a natural next step.
Yeah.
And I think they will overcome it, and it will be driven to a large degree, again, by the consumer. When clients start getting comfortable with the fact that they can reduce disclosure budgets, which are somewhere around 70% of what people expend on cases, by hundreds of thousands of review hours or pounds, they're the ones that will end up pushing for it. And the information's there. It's not, when you look at the information, it's consistent. It's more consistent than 20 paralegals at 3 a.m. spilling McDonald's all over the files. But it's also in terms of what it captures and what it doesn't capture. There's no evidence to say that human eyes on it is any better. And so I think when people get more comfortable with it, it will become more common in practice.
Joe, not to kind of put you on the spot, but maybe kind of come back to you and the knowledge of at a firm. And this is not to plug Relativity Fest, London. No, but it's
maybe a little.
I did it. I wasn't going to. But you talk about the knowledge and kind of people getting your colleagues getting exposure to something like this so they can know more about what's going on. I mean, is there anything else? I don't know. Is there anything kind of internally that like the firm is doing to kind of be proactive and kind of getting everyone on a certain level?
Yeah. Well, I think
thoughts like that?
certainly. So we have. We don't have an in-house FTech team as such, but we have a small sort of knowledge team which is leading the way in terms of not just assisted review, but just generally the technology options that are available and how they can assist us and the client in the litigation process. It's actually quite funny because that knowledge team is really focusing on the associates, and I think partly it is a generational thing for the associates to sort of soak up all that knowledge and take matters forward, because ultimately, as this is going to take a few years, I think, to keep progressing, it's going to be us guys in the next few years which are going to sort of be selling assisted review to the clients and paving the way forward. And we're doing quite a lot. We're doing a lot of work with vendors across the whole space, I think, just to see what each and every vendor are doing in respect of this area and how you guys can help the lawyers and give us the knowledge that we need to sort of promote it to the end client to get them on board. But as I say, I think it does depend on the right case. And at the moment, whether it's right or not, there seems to be a sort of reluctance in the industry to use assisted review for sort of the day-to-day cases. And we're sort of all waiting. Yes, the massive, big Schengen type cases, assisted review is going to be brilliant for, but they don't come. We're not working on those every single day. So perhaps it's just, I don't know whether, I think perhaps just in time it will become something that we use more and more of.
Any kind of, I guess just to kind of close off on this, and maybe Al, maybe kind of coming to you on this one, and not, she mentioned like being from a vendor side, kind of scoping, seeing what's out there, seeing what tools or kind of how a vendor presents. Anything from a comment from the vendor side of things, like being proactive with the firm and kind of going in and saying, we can provide this, or even if it's kind of breaking down the door of just general analytics. Any comments from that perspective?
I think information's a big thing. So in knowledge pieces, whether that's speaking or whether that's offering to write bulletins together with law firms, whether it's going in there and showing them how the technology works, particularly to the associates, whether it's at the end of a case actually saying, okay, it's all done now, we have your data, there are no problems with us having it, we can actually, if you have some time, run various analytics on it and show you the benefits of it. I was speaking to one senior associate the other day who was saying their big, the big benefit to them of using technology is if there's a way of freeing up more junior people's time than reviewing hundreds and hundreds of irrelevant documents, where they can do legal training which will make them better lawyers, then they're all for the use of technology. So rather than it being a cost saving and a time saving, actually qualitatively making lawyers better at what they're meant to be doing. So I think that the newer generation of lawyers are all for it. And as with anything, it will just take some time to take hold.
Yeah, no, I have to agree. I think it's about changing it's about changing how legal firms see how predictive. I mean, they assume that predictive coding is taking away their ability to make a choice on a document, and I think it's about we have to go out and we have to show them and demonstrate that that's not the case. That we have to show them how the technology is taking their decision and just amplifying it throughout the data set that they have. And I think really, yeah, you're right. We need to, it's demoing this software and these features and showing them how they work. Because it is different from general analytics. General analytics I see as just an extra tool on your tool belt to find things a little bit quicker, or to structure data in a different way to help you understand it a little bit better. But it doesn't go and find documents for you and tell you whether documents are relevant or not. I mean, there are documents in assisted review that you might never see. You might never review them because the computer's made a decision that this document is conceptually the same as this document, and you've called that one relevant, so that one's relevant as well. And so it's about showing and demonstrating how that software works and how it isn't taking away the decision of an associate or a senior associate on a matter.
I love your kind of comment on that. Well, try it on a case.
Yeah.
Even if the case is kind of old or it's already been reviewed, but the whole kind of the time and the effort and getting people on board to kind of help do that and revisit. I know it's easier said than done.
Absolutely. Yeah.
But any kind of from the panel, any kind of closing thoughts? Thinking about 2018, not a plug for any sort of event by Relativity, but where are we then? Do we think we're talking about this in a little bit different, or is that a bit too soon? Maybe you see obviously anything you're seeing on an increase in cases.
I think we're talking 2018. I think. It's a slow trend. It's going to be a slow trend taking on assisted review, as it is with all technology. I mean, assisted review has been around for a long time. People will get more familiar with it. As you said, the junior associates and the younger generation of associates are on board with this, but they don't necessarily drive the decisions behind, how we decide what technology we use for a particular project and so on. So I think it's about just sharing how the technology works, sharing the workflows technology with law firms so that they can become familiar and comfortable with it. And then, only then really will the clients really become familiar and comfortable with it. It's definitely something that the law firms need to focus on.
And I think the way forward, and I'm already seeing this already, not just about assisted review, but about technology generally, and this has come up today, but I think going forward it will be a much more collaborative approach. Previously, I think the vendors have sometimes been seen as an add-on, which we're either bringing them in too late, or they're just doing a sort of isolated service for us. But actually, now that these cases generally are getting bigger and bigger. The documents involved in the cases are just getting enormous, and we just simply don't know what to do with them anymore. There's just too many documents. I think I'm definitely seeing a sort of more of a two-pronged approach with the vendors and the law firms approaching the client together. And as Al says, in the US, the vendors are sort of approaching the clients direct, so the clients are already on board with that. And I think going forward, it will just be more of a process of each of us all working together and putting our proposal to the client together, whether we use some sort of demonstration to show the advantages of doing that. But I can just see the vendors coming in at a much earlier process, helping out with the EDQs even more than they're doing so now, and sort of all working together. And I think that's the way forward. A bit like what I said earlier about the law firms meeting the entire team. We don't just want to see the consultants and the sales guys who do brilliant jobs, but we need to really see the whole team, and I think that's how it will work better going forward.
I think it's unavoidable. There's an exponential growth of data, corporates having to deal with hundreds more issues, whether it's cybersecurity, litigation readiness. They're getting more savvy to the fact there is technology to deal with all of this out there. And law firms are going to be, the ones that aren't early adopters, they're going to be forced by their clients to do it. They just can't deal with some of the issues that they're seeing today. And I think, there are some of the bigger firms already have internal teams that deal with this. Some of the medium-sized firms are looking at taking on managed services, so they feel like they're offering that service internally. And I think over 2018, you're going to see a lot more of this collaboration where both are in at source to advise together. We're seeing it already. We pitch with some smaller firms for work where end clients sometimes have a concern about the capacity or the tech or the resource. And it's only going to go one way.
Well, hopefully this time next year we'll do a round two, kind of see where we're at in our predictions.
Catch up.
But with that said, again, we can kind of open it up to the crowd. If anyone had any questions or any comments, or if there's any last thoughts from our panel to pass on. Yes.
I would just like to make a point that predictive coding can be used to prioritize the documents, so prioritize the review, basically. Do you think that can be considered for it? For example, we've had a client who wanted to review 30,000 documents, and they wanted to start at a important end, the review. So we suggested to them to use predictive coding to prioritize what of the 30,000 you should be reviewing first. And this way, when they do the first level review using predictive coding, and the first level reviewers start reviewing the prioritized documents, the second level reviewers get the important documents first filtered through to them as the case goes on or the review goes on. You think that's the right approach?
Yeah, I think it's one of many approaches. And yet I've seen that same workflow being used on matters before. So essentially just taking a set of data that maybe you know the key date ranges and you have some keywords already, taking that data, reviewing that first and pushing that through predictive coding to just amplify that initial review, and perhaps still reviewing the rest of the documents in a linear form. It comes down to workflow again, whether it's the vendors or the technologists or the discovery teams that are driving that those workflows. But it's about sharing them and talking about them, and just working with legal teams to present workflows like this that can help save them time and money in their matters.
It seems to be the right approach to introduce predictive coding to the legal teams, and once they start trusting this process, they can move on to the next step of pretty accepting the coding.
Yeah.
It's something Master Matthews talks about in Piro. He says that traditionally lawyers review everything chronologically, but where technology exists, whether it's predictive coding or clustering or any other form, more like where the technology exists to look at the important documents first, then the parties should be engaging with that as soon as possible.
So I use prioritising a lot, actually, and I think it's very useful, although I would still do it from the keyword searches rather than the predictive coding at the moment. But definitely, as Al says, I think that it's definitely the way forward. The better you can prioritise the documents. You don't need to review them in chronological order. It's much better to have the key documents up front and get those through the second pass review, and then let the first level sort of keep going with the lesser important documents.
Okay, thank you.
Thank you. And actually, I'll take that as a time. I know we're right about time, and if there are any other questions, do let us know. But it kind of highlighted a point right there, Nick, that you were saying. It's yes, that could be one workflow. That it sounds logical. It sounds like it makes sense. But talk, kind of summarizing our session here. Teamwork in tech, right? So if the lawyer has they've got their case, talk to your teams, talk to your internal team, talk to your vendor. Data collections, right? Engage your internal team, engage your vendor. Work together. So kind of I'll put that in as a nice kind of closing comment to this session. But any questions, please feel free to come up, catch us afterwards or during the break. And thank you again to the panel for coming today.
Thank you.